Good. And we always forget music. Every single time we have a training, we're like, it gets quiet during the intros time, and we always forget to play music. So apologies.
That's interesting.
Let me spotlight.
We could have a theme song, Joanne, for
For open government, yes. Add spotlight. Great. So I think we are going to go ahead and get started as more folks are joining us. And hopefully, if you are someone who needs, what do you call it, auto captioning, you should see that option at the bottom of your screen if that is needed. So if you don't, please let us know. So again, good afternoon, everyone. I am so happy that you all are joining us. My name is Joanne Antoine. I serve as Executive Director of Common Cause Maryland. And I'm just so happy that you all have made time to join us this afternoon. Also, happy Sunshine Week. If you are not familiar with Sunshine Week, it is a national celebration of access to information and your right as Marylanders, you know, to know. And I think it's timely because I just realized it's also the Freedom of Information Act Day. This is all part of Sunshine Week, which again covers our conversation today largely in regards to your ability to access information. Now, for those who just aren't familiar with Common Cause, we are a nonpartisan good governance group that is focused largely on how our government functions. And this includes ensuring transparency at all levels of government. You know, I think as an organization, we understand and we know that public how would I say, greater transparency leads to accountability in our government decisions and even the implementation of those decisions. We are also one of the organizations that leads a statewide coalition called MDOG, or Marylanders for Open Government. You know, we work in partnership with organizations like MDDC Press Association, ACLU, and other organizations. And collectively, we worked on reforms that has led to the creation of the Ombuds program, the compliance board, and, you know, we're continuing to work on making improvements to open meetings and so forth. So with that said, I don't want to go on for too long. I just want to thank you all again for joining in celebration of Sunshine Week, for taking time out to learn about your right to access government information, and obviously to our speakers who are joining us today. So I am not going to be the lead of the event today. We're actually grateful to have the Public Access Ombuds and members of her team joining to walk us through a very detailed training. You all will have the ability to ask questions throughout the event. And if you have to jump off early for any reason, it is being recorded. We will be sending that information out following the training. And before I pass it on, I did want to give a shout out to our fellow who is on as well, Isabel Malizia, who is helping to monitor the chat and who is always willing to help us with everything. So with that said, I am going to pass it to Spencer and Lisa, who will be leading us today. And again, thank you all so much for agreeing to partner with us.
Thank you, Joanne, for the invitation today. We're very thrilled to be here. Before I give the mic over to Lisa, just wanted to say hi, introduce myself. I'm Spencer Dobb. I'm the Administrative Officer with the Attorney General's Office Public Access Unit. I provide administrative support to the Public Access Ombudsman as well as the PIA Compliance Board. And then I have a third hat too, where I do provide some support to the Open Meetings Compliance Board, but 99% of my job is supporting Lisa in trying to resolve PIA-related disputes during the mediation process before it is potentially eligible to go to the board. So as Joanne said, we are very happy to take questions during the training. We encourage folks to raise their hands or to type their questions in chat, and we will certainly get to them to the best of our ability. We do have a couple of breakpoints built in for questions, but certainly if we're in a section, we're covering a topic that you have a question on, please please feel free to speak up and ask us. Along with the video afterwards, we've arranged with Joanne to provide a copy of this presentation and some additional resources that we flagged as potentially of interest to everyone that's here today. And then at the end of our presentation is our office's contact information. So if we're unable to answer your question today, or if you want to reach out, say hi, if you have a question, if you have an issue, if we can be of assistance, reach out to us. We are very accessible by phone and by email, both, and we are always happy to take the call to see how we can better assist you. And then just one last thing, due to the confidential nature of the mediation program, if you ask a question, we do ask that it not be related to any matter that may be pending with our office. We do have to protect the confidentiality of what we are addressing through mediation and through our program. So broader questions, not specific questions, we can entertain, but in the event that we can't assist you, we'll ask if we can connect directly. So with that, Lisa, I'm going to turn it over to you. Just let me try to get the presentation up here real quick.
Thank you, Spence, and Joanne and team for the invitation and the wonderful introduction. As mentioned, I'm the Public Access Ombudsman. It's a role that I've been in since we first opened our doors in 2016. And my primary mission is to try to help agencies and requesters resolve disputes that come up under the Maryland Public Information Act through essentially a mediation process, through dialogue, through exploration of options, sometimes just trying to improve communications and other tools of that nature. Today, we're going to be talking obviously about the Public Information Act. It is one of Maryland's chief open government laws, and it is focused on access to public records. So that's what we're going to be talking about today. And you know me, Public Access Ombudsman, and you've met Spencer. Spencer is very well known to all of our program users. He's usually the first point of contact and has a lot to do with shaping and defining disputes so that they can be more readily resolved. He is in many ways the hub and the engine that makes this program work. You know, government sunshine laws are so called because they share as their main purpose to shed light and provide a means for shedding light on government activities or inactivities, as the case may be. And of course, the Public Information Act does that by focusing on access to public records. There are other open government laws that focus on other types of government activities, such as meetings, such as financial disclosure rules, ethics, and other requirements. But today we're going to be talking about access to records. We're going to talk about and touch on each of the main components of the Act with the purpose of giving you a better understanding of the major parts of this important law, how they work together, and that will enable you to use it more effectively. So we're going to go over some the general rule of disclosure that the Act provides. We'll go over some of the basic definitions in the Act, which are often key to understanding what the specific terms mean. We're going to go over the exemptions landscape. Exemption is the word the Act uses to describe exceptions to the general rule of disclosure. So they are very important, and they come in a couple of main varieties, either mandatory or discretionary. We'll be talking about that. The Act provides deadlines and timeframes by which agencies should respond to requests. We'll spend some time talking about that. Agencies are allowed to charge fees under certain circumstances, and requesters are allowed to ask for waivers of fees. So we'll discuss how those components work. And then we will, in wrapping this up, talk about remedies and enforcement, which will bring us to kind of the role of my office, the role of the compliance board, and the role of the courts when access to the courts may be needed. And then we will, of course, give you some contact information so you can get in touch with us and alert you to other important resources that are available to you online and at no charge. So in many ways, this is a back to basics course, the basics of the PIA. So the Public Information Act is a statute, meaning it is a law passed by the Maryland General Assembly. It was passed back in 1970, so it is it's been on the books quite a while. For those of you who like to do your own research, it's found in the General Provisions article of the Maryland Code in sections 4101 through 4601. In hard copy form, it takes up about 200 pages. So it's a bit of a lengthy law. In the lower right-hand corner, you'll see a little icon to the PIA manual, Appendix E. And we wanted to highlight that for you because, first of all, the PIA manual is the kind of the Bible in Maryland to the Public Information Act. And Appendix E has the full text of the statute. So anybody who wants to read it can find it very readily there.
And one thing I would add, well, besides apparently the formatting was thrown off when I put this presentation on another computer, so I do apologize for some of the weird spacing. But when we provide you the PDF version of this presentation after this session, those links that you'll see throughout the presentation, like in the lower right-hand corner, they'll work in the PDF. So you'll be able to click and go directly to where we're referencing it and get the information that we're talking about in greater detail.
Thanks, Spence. That's great. So the general rule and guiding principle that underlies the Public Information Act is to provide a general right of information to the public. It provides that all persons are entitled to have access to information about the affairs of government and the official acts of public officials and employees. Subsection B has been viewed by the courts as kind of a rule of interpretation that applies throughout the act and is to guide how the rest of the act is to be interpreted. And that is, unless an unwarranted invasion of, okay, Spence, I'm going to have to do something here because I'm seeing everybody's blocking the text here. So I'm not going to be able to read it to you because I've got something else blocking it, but I trust you can see it. In general, unless an unwarranted invasion of privacy would result, the title is to be construed, is to be interpreted in such a way as in favor of allowing inspection of a public record with the least cost and least delay to the person or governmental unit that requests it. So this is kind of a default rule of interpretation. When in doubt, look to this rule of interpretation. Unless there's some unwarranted invasion of privacy, these guiding principles apply. Okay. So we talked about the general right of information. 4201 is the section that actually defines the right of the public to request inspection of public records. The Act actually deals both with a right of inspection of public records and a right to obtain copies of public records. There are two distinct rights under the Act. In general, the Act is to be construed in favor of allowing inspection. It is a very broad right. Except as otherwise provided by law, a custodian shall permit inspection at any reasonable time. So unless there's something else in the law that would trump the PIA, inspection is to be allowed at upon reasonable notice and at any reasonable time. Generally, the purpose of the request does not matter. And in case there is a rule of law that requires some material to be withheld, the law directs agencies to redact or to block out that which cannot be produced and provide the rest. So the Act is always pushing and directing agencies to produce everything that can be produced, withhold only when there's a specific exemption or exception that directs you to do that. Those principles, by the way, will be, which we can discuss a little more later, but that can be important to how you frame your requests. And we'll talk a little bit more later about some guidelines and tips to making effective requests. The Maryland Public Information Act, first of all, it only applies to entities within Maryland. It has nothing to do with any federal agencies, but it does apply to state and local government bodies, both within the executive and legislative branches. And it applies to governmental or quasi-governmental entities that are viewed as instrumentalities of government. So these are typically lesser known bodies, but they very frequently are creations of law. They are creations of the state. So for example, when you get these bi-county commissions and tri-county commissions or a special commission on X, many of these will be viewed as instrumentalities of government that are subject to the Act. Importantly, the Act does not apply at all to records in the possession of the judiciary. So it doesn't apply to any records that the courts may hold or that the administrative office of the courts may hold. And it also, just to underscore, does not apply to any private entities. The Public Information Act does not speak to anything that a private party has to do. It doesn't address that in any way, shape, or form. So probably the key definition in the most important definition in the Act is that of a public record, because that is what the Act is giving you a right to. And the definition section is 4101. Public record is definition K, and it's a very broad definition. It includes any documentary material made or received by the agency in connection with the transaction of public business in any form. In any form. So the keys there, I think, are in connection with the transaction of public business, something that's a part of, it's either made or acquired in the course of carrying out public business in any form whatsoever. The Act does not, we'll come to this to discuss it in a little bit more depth, but the Act does not require agencies to create new records on request. In other words, if it doesn't have a record that you want, the proper response is usually, we don't have that record. So that is an important kind of guidepost for the Act. Another term of art used in the Act is that of a custodian. The Act imposes duties on custodians, and they come in two varieties. One is the official custodian, and that is the person who is legally responsible for the body's compliance with law. And very frequently, that's going to be the head of the agency, the top person who has legal responsibility for that entity. And then there are actual custodians or custodians in fact, and this would include anyone who lawfully has custody and control of the record. So there can be, and frequently are, multiple custodians of the same record, both within an agency and across agencies. Anybody who has the record and is authorized to have it as part of their carrying out their public business is a custodian under the Act. Again, we have our icon referring you to Appendix J, and that is because Appendix J is a listing of the custodian of the PIA contacts for agencies throughout Maryland that are subject to it. Under this law, agencies are required to designate someone to coordinate or respond and oversee the agency's compliance with the Public Information Act. Agencies are required to report that identity to the Office of the Attorney General so that it can be published in this form. And, it is not a perfect listing in the sense that it is not always 100% up to date, but it is certainly a good starting point. If you are looking to try to find out to whom I should send a request, Appendix J in the manual is a good starting point. Spence, did you have some more tips on that?
Yeah, so I actually do manage Appendix J. We ask that custodians provide the contact information to the boards, PI compliance boards dedicated to inbox, and then I submit those revisions on a monthly basis, usually the first of the month. We update the contacts on the website. So if you're ever having any issues finding out who do I need to contact to submit a PIA request to, you can always reach out to us. If the information isn't available on the website, it might be available in Appendix J. Sometimes because folks do leave positions and others get the hat to respond to PIA requests, there may be a more current contact than what's published. It just hasn't been updated yet. So definitely, if you have any issues, reach out to us. We're more than happy to try to figure out who you need to contact and how you can contact them.
Thanks, Spence. Okay. Who is a person in interest? This person in interest is another term of art defined in the Act, and it comes into play most often in the context of certain exemptions, which we'll touch on later. But generally speaking, a person in interest is the person who is the subject of the record, the person the record is about. So that can be an individual, it can be a governmental unit. If the person is a minor or someone with a legal disability, it can be that person's parent or legal representative. But generally, it is the key point is it's the person the record is about. Sometimes it is important for certain purposes, if you are a person in interest, to say so, to make that clear in your request. Generally speaking, persons in interest have broader rights to some types of records than the rest of the world. And so that's the reason for flagging that here. Okay, what is a PIA request and what do you have to do to make one? The Act is intended to be very user-friendly. It is not about magic words or lawyering up. Any written request for records is a PIA request. When the Act says any written request for records is a PIA request, it means just that. You can write a letter and say, please provide X. You can send an email, please provide X. And that is a PIA request. Bearing in mind, as I think I touched upon earlier, an agency is not required to create a record. We'll talk a little bit more about sometimes the context in which that can become an issue. You don't need to use any magic words in order to make a PIA request. You do not need to even say that it is a PIA request. Sometimes it's helpful to say it's a PIA request because you are then flagging it automatically for hey, this is a Public Information Act request. And in the eyes of people who have any experience with the Act, they will know immediately that means I have certain timeframes I'm working under and certain guidelines and rules. So we recommend that you say it's a PIA request, but your request cannot be bounced because you failed to say so. Again, the manual, we're going to refer periodically to the appendices in the PIA manual because they contain lots of helpful examples and information. Appendix A is a sample request letter. So if you want to see an example, that will give you a good model. Spence, was there something?
Yeah, something I might add too through the pandemic and in today's modern age where we do so much work virtually, a lot of agencies do have web forms that you will fill out to submit PIA requests. Some of those web forms are good and they bounce a receipt back to the email that you provide. Others, not so much. It may be a security reason, it may be a functionality reason. If you're submitting a written request for records through a web form, and there's potential that you may need to contact our office to request mediation assistance to resolve a dispute. Something that I've been seeing more and more is folks don't have copies of whatever they provided through the web form. So one of the recommendations I would give is just as you're filling in the blocks on the form, maybe open up a Word document and copy and paste whatever you put in there and then save it. So that way you have a record of the original request. So that way, if an issue comes up and we're reviewing it to try to mediate the dispute, we can see the exact language that you submitted to figure out, all right, what did you request and how did the agency respond? Having that original source is really, really helpful for our program.
That's an excellent point. It's really a key point because agencies are going to respond to the written, generally speaking, they're going to respond to the written request as it is made. And that may or may not match up with what you intended. Or what you really are interested in. So what we're going to talk a little bit more about how those gaps can be addressed a little better. But keeping a record of your request is key. So here are some tips that I would offer, our office would offer for making requests. Really try to make them simple and straightforward. And the opposite is true. Don't make them unnecessarily complicated or convoluted. Simple requests get answered more quickly, more readily, and with less expense. The more complicated it is, the more difficult it may be for the agency to figure out what you really want and to respond to it fully. So if you know what you want, just ask for that. Ask for that thing. Which brings me to point 2, make your request as specific and precise as possible. For example, I want a copy of your budget for fiscal year 21, not I want your recent budget, all your recent budgets or all your recent budget requests. That will use of terms like recent and other kind of descriptives that are not very precise may leave an agency kind of scratching their head. What does this really mean? What does this person really want? So it's usually much more efficient to be as specific as you can be. Treat people as you want to be treated. I mean, this is, apply the golden rule. So oftentimes there are problems or issues that underlie a person making a request, and there may not be the best relationship or feeling between the parties. But in your request, I mean, strive hard to be cordial, collegial, and to address the public workers who have to respond to your request in a very civil and cordial fashion. Regardless of what your issue or problem may be with the agency. Identify your request as a PIA request and follow agency procedures for submitting a request. So this is not a requirement of the Act, it's just a tip that will help agencies address your request faster and more efficiently. If they know it's a PIA request, they will know certain rules apply. If you use their procedures, the procedures they're asking you to use, again, it is more likely to be addressed more rapidly, more efficiently by the people who are most knowledgeable about what you're asking for. When requests come in by other means, they're legally valid requests. That's not the issue. But what can happen is they may not be recognized as PIA requests, or they may go to someone who doesn't know what to do with a PIA request. And so they may go to the bottom of the pile, or they may be mishandled. Not through any malevolence, but in the press of business, it may not be addressed as efficiently as it would otherwise. So our suggestion would be to make your request simple, clear, concise, be as specific as you can, be as nice as you can, and when you're making a PIA request, flag it as such. Flag it so that whoever gets it will know immediately this is what it is.
One of the things that, as we were preparing for this, Lisa and I were talking about is we recently had a matter come through a mediation without getting into any specifics in the interest of confidentiality. It became apparent throughout the mediation that the request was for this giant volume of records over here when really the requester was trying to get at B, a very unique and specific record itself. And so in making the request for A, it was responded to with a large fee that was the subject of the dispute for records that spanned potentially decades. And once we were able to work out, all right, the heart of the request really is for this specific record, the fee issue went away and the agency was able to respond fairly rapidly to it. So the more simple the request, the better. Obviously, not every request can be simple depending on what you're seeking. But really getting at the heart instead of dancing around a request. If you're looking for something in particular, don't be afraid to ask for it in the most blunt of terms as possible.
That's an excellent point, and which, just to underscore, agency staff are going to respond to a request as it is written. They are not necessarily going to know that what you had in mind, what you really want, is something over here. If the request reads as encompassing a large, potentially a very large volume, that's what they're going to be addressed. That's what they will try to address. So you can help yourself and you can help them help you just by keeping it simple. Okay, we can go to the next. One of the challenges.
There's actually a question in the chat from C. Hoffman.
Okay.
That says, if you have a very general request, quote unquote, all records related to ... can you respond back to ask specifically what the requester is looking for? In my office, I am the one fulfilling the request. I think that the next slide may actually get to this question.
Yep, it does.
We can go ahead and move on to that.
Okay, so when I'm doing these trainings for agencies, these are the kind of tips that I will frequently try to underscore with agency staff. Absolutely communicate with the requester. If you are not sure what they are looking for, of course you can pick up the phone and call them and ask, or pop them an email and say, can you help me understand what you're really looking for? Steve, what you observed, I think, is absolutely appropriate. By all means, communication, good communication will solve a lot of problems. It will preempt a lot of problems. So it is a good general rule of thumb. The flip side is never, never, never simply ignore a request. That only leads to trouble, only leads to misunderstanding, confusion, and is obviously not what the PIA is directing. Sometimes we have to remind agencies that even though they may have their preferred procedure for receiving PIA requests, the Act itself doesn't limit requests in that way. So any written request for records that comes in has to be addressed as a PIA request. When there are fees involved or anticipated, agencies are directed to estimate what the fees are and to notify the requester in advance and to give them some indication of why the fees are being estimated, so that you don't hit the requester with a bill at the end. So most agencies I have found actually do try to do this. They will reach out and give a fee estimate in advance, and very frequently they will ask for payment in advance. Certainly they will try to do that if it's a very substantial fee. We're going to talk more about fees in greater detail. Of course, I give the same advice to agency staff: always treat people as you want to be treated. You're busy, you're overworked, you've got a million pressures on you. Nonetheless, you're a public servant. You have to be polite, respectful, and give the kind of assistance that you would want to get.
There's a question from Kurt in the chat, and he does lead with this question can be addressed at another more appropriate time if we can't answer it here and now. But he asks, given his previous career in county government, he knows a lot about what data is available and in what form, but many citizens don't. Is there a way to help avoid the quote unquote guessing game? For example, when it comes to financial data, most governmental entities have financial system manuals or set of manuals. Most governments have defined quote chart of accounts with some basic explanation of the various parts and technical documentation regarding the tables/files used in the system, including basic and very standardized data dictionaries. That sort of data is disclosable, correct?
Spence, you were reading that a little quickly for me, and I cannot actually see it. But the general answer is, unless there is something in the PIA itself or in another law that would preclude it from being disclosed, yes, it is disclosable. From this general description, I think it is disclosable. It sounds to me that it would be. I think Kurt is really touching on, in some ways, one of the challenges that really face requesters generally, which is requesters often don't know how an agency maintains its records, what records it has, what resources it has. So you don't know what to ask for. You don't know exactly what to ask for. And so there are some tools that are available that can help a requester learn more about that up front, such as, perhaps information posted to a website. There is, for the first time now, we'll get to this a little bit later, a requirement of proactive disclosure of for those materials that can be proactively disclosed. And you do encourage proactive disclosure. Proactive disclosure is a wonderful, wonderful tool for both the agency and requester. It helps the agency because they are then unburdened of having to repeatedly respond to requests for things that are often in demand. And it's a great benefit to the requester because they don't have to go through the PIA process. They can go on the website and find it. Doing a little bit of homework, poking around on a website can frequently pay big dividends in terms of cutting through some of the common problems that cause delay in the process. Did I answer that question? I did. Okay. It's hard for me. It's hard because I can't see it. I don't know what's happening with my screen here. Okay, next. Okay, so we mentioned Appendix J as having the listing of agency representatives, and that's the list that Spence manages. Can be a very useful starting point for making a request. If you need to find out who to contact at an agency, this listing can be very useful. We use it quite often when we have issues come up. We need to know who do we go to in an agency to get this straightened out, and very frequently it will be the designated representative. What is proactive disclosure? Well, it is just what its name would suggest. It is the disclosure of records and information without any request having been made for it. So it is it is a very efficient way of disseminating public information, to the extent agencies will engage it. There were changes made to the Public Information Act that went into effect last July under a bill that Joanne and many others worked on. And for the first time, it now contains a requirement that agencies that are subject to the Act have a policy of proactive disclosure. And that provides for proactive disclosure of those records that they are able to proactively disclose, meaning there are no confidentiality issues, no exemption issues, and allows the agency to devise the means by which they will make that form of disclosure, for website being probably the most common. If you want to see examples, I frequently tell agencies, they say, what do I have to have in my policy? I say, well, if you want to see an example, you can go to the board website, you can go to the Ombudsman website. We all have policies of proactive disclosure now, and we post them to our website. This is a very big, by the way, the federal government has really taken the lead on and really developed the proactive disclosure mechanism. And they've really had to because of the volume, the sheer volume of requests that they receive. What does an agency have to do in terms of looking for records once you make your requests? They have to make a diligent search. They have to look in places where they would expect the record to be kept. No, they do not have to turn over every stone, open up every file drawer, but they do need to make a reasonable effort by looking wherever they think a record of that type would be maintained. With complicated or large requests, we often will recommend to agencies that they keep track of what sources they're searching. If it involves email searches for emails or databases, we ask them to keep track of the search terms that they are using. And this can be important for any number of reasons. Number one, if someone questions whether an adequate search has been made, it can be very helpful to know exactly what was done to look for records. If there are fee issues that come up, sometimes it can be very helpful to know exactly what was involved in trying to respond to this request. So there can be myriad reasons for documenting exactly what's being done to look for records.
Just to jump on that, for an anecdote, we've had a couple of matters come through our office in the last year or so where an individual had some concerns about the potential diligence that was exercised by the agency in conducting the search and responding to the record. The agencies oftentimes ended up responding with it. They weren't the custodian of the record. And so we, of course, opened up the mediation file because it's something that Lisa can address through our program. And we've been able to bring these matters to successful resolution because the agencies have kept kind of notes on what efforts they took, what terms they searched, where they looked, who they may have contacted. And that really did give the requesters peace of mind that, you know, all right, the agency really did their best. Some even went above and beyond, well beyond what the PIA requires with their searches and reaching out to other agencies, which from a customer service perspective, I enjoy. I really respect that of agencies. And then sometimes it really is just a function of records that are older. They may have been disposed of in accordance with records retention schedules that each agency does have their own schedules for. So that level of detail, that level of communication certainly factors in to some of these PIA requests. And if you ever have those doubts, feel free to let us know.
Thank you, Spence. Those are good points. Okay, so you know, in our information age now, so much of government is managed electronically, information stored in databases, and more we see issues coming up about access to data as such. There is a section of the Act that provides that if a requester asks for records in a searchable and analyzable format, that agencies are required to provide it in that format if it's available, and if they're able to do it without compromising any exempt confidential information. What they're not required to do is go out and buy a new database program in order to compile the data for you. But if they have the ability through their ordinary functional means to extract data that you are seeking, and they can do it without jeopardizing confidentiality, then they are required to do it. There is a court case that has decided the question of whether, if you ask for some subset of data, for example, are you asking for a new record to be created? And we have a case here in Maryland that considered this some years ago and said, no, it is not creating a new record if the agency can extract the data using ordinary means. So I think that'll take us right to the next slide, Spence, to give us an example. This was an example of a data request. Requester sought a list of the top 5,000 accounts that were maintained by the state controller's office, consisting of a list of abandoned property accounts. This is a list the controller is required by law to maintain, and it's a huge database. And the requester was only interested in the top 5,000. And so one of the objections the agency made to responding to this request was that to extract this data would have been to create a new record. Because you're asking us to pull out some subset of the data. And the case cited, Comptroller versus Emanuel, stands for the principle that that is not creating a new record within the meaning of the act, that's a perfectly permissible request to make. The agency is obligated to respond to it, provided it is within their, ordinary functionality, provided that they have the means to do it. This is really a very important point for anyone who is making data requests to governmental agencies for research purposes, news purposes, advocacy purposes, for any purpose whatsoever. It's an important point to remember. Okay, now we're going to get to PIA exemptions. These are the exceptions to the general rule of disclosure. And we're going to talk about three categories. Well, those that are mandatory and prohibit disclosure, those that are discretionary and merely allow an agency to withhold. And then there's a special category for records that a court may order to be withheld. With that said, let's dive into the topic of exemption. Spence?
Right before we dive in, Mr. Gregory Davis posed a question in chat. Is PIA used in background checks in establishing security clearance levels for employment purposes?
I have seen instances where there were attempts to use the PIA to gain records as part of a background check. So yes, I mean, anyone can make a PIA request for any purpose whatsoever. And background checks, curiosity, entertainment, political, it doesn't matter what the purpose is. The only really relevant question is the record disclosable or is it not disclosable? And that's what we're getting to with exemptions. So, but yes, I have seen that.
And I would even add in there insurance claims for like auto accidents. I've seen a couple of matters come through for that.
So the general landscape of exemptions under the Act are Part 1 deals with mandatory exemptions that are derived from sources of law that are outside the PIA, meaning you're not going to find them in the PIA, you will find them elsewhere in the law. But when they are applicable and they're mandatory, an agency must withhold the records. Part 2 deals with mandatory exemptions that are provided for in the PIA itself that apply to specific records. And we'll go through some examples. Part 3 applies to exemptions that are mandatory, but they only apply to certain information. So that could be information within a record. When those exemptions apply, that specific information has to be redacted. Part 4, which in some ways I consider the trickiest part of the exemptions law, are discretionary exemptions. And those are exemptions that they don't prohibit an agency from releasing records, they permit an agency to withhold records under certain circumstances. So we'll be talking a little more about that. Part 5 is the special provision that relates to court orders. And it really relates to a mechanism by which agencies can go to court and get an order authorizing them to withhold records that they might otherwise be required to disclose under the Act. We'll talk, it's a very rarely used procedure, but we'll talk a little bit about that just so you're aware of it. So Section 4301 is the section of the Act that generally governs mandatory exemptions that are sourced outside of the PIA. And that includes, for example, common law privileges that have developed over time through application in court cases primarily, such as the attorney-client privilege, the executive privilege, which is a little lesser known privilege. But if those of you who may remember the Watergate hearings, I mean, this was something that goes back that far. Legislative privilege is a form of privilege that applies to certain types of debate that occur in legislative settings, consideration of legislation. Grand jury privilege, as the title suggests, pertains to materials that are obtained and considered and presented to grand juries. It's a very specific type of mandatory privilege. When it applies, it's a bar. It bars release of the record. Then there are other statutes in Maryland, other than the PIA, that contain provisions that prohibit the release of certain types of records. So, for example, there are provisions in the Courts and Judicial Proceedings article that place very strict limits on what can be released in records pertaining to juveniles, to minors. And there are many different scenarios in which records pertaining to juveniles have to be withheld or redacted. Tax information is another one. There's a state statute that governs the disclosure of tax information. In addition to our common law privileges, in addition to the other state statutes that can come into play, federal statutes and regulations can also be a source of a mandatory exemption. So a very common one would be HIPAA, the Health Insurance Portability and Accountability Act. Some of you may have encountered FERPA, which is a federal statute that applies to student information and records that may be in the possession of school districts and other educational institutions. Very strict limits on what can be disclosed or not disclosed. And there are many others. There are many other federal statutes that can come into play. Court rules and orders. If a court orders that a document is to be withheld, for example, places it under seal, or issues an order authorizing an agency to withhold a record, that court order will trump the PIA. So there, as you can see, there are many potential sources of exceptions to the general rule of disclosure. Part 2 exemptions relate to mandatory exemptions covering specific records. So you're going to get a copy of these slides. You don't need to memorize this. In fact, you couldn't memorize it. There are many more than we've listed. But this is just to give you an example of the variety of exemptions that are in the Act, that when they apply, they are mandatory, and they prohibit an agency from releasing records of that type. So some of these are pretty obvious as to why they exist: firearm and handgun records, security of information systems, personnel records, arrest warrants and charging documents before they are served. Distribution lists is a more recent one. It applies to lists that are maintained by agencies solely for the purpose of communicating with their constituents. So, and there are many others in the Act, but these are just to highlight some that come up often, and to make you, we could title this section of the program, the devil is in the detail, because there's lots and lots of these things, lots and lots of exemptions. Okay. Mandatory personnel records is an exemption that comes up quite frequently, and basically the purpose of this exemption is to protect the privacy of individual employees. And so it prohibits release of records that pertain to a person's employment. And that has generally been construed to mean anything that has to do with their hiring, their performance evaluations, anything they submit as part of their candidacy for a job, and anything to do with discipline, promotion, grievances. Up until very recently, police internal affairs files that were basically investigative files having to do with alleged police misconduct were authorized to be withheld on a mandatory basis as personnel records under a court case and by our highest court, now this is known as the Supreme Court in Maryland. That has been changed legislatively, and we'll get to that in a moment. But as you can see, the personnel records exemption has lots of applications to individuals who are employed in government. It does not apply to statistical or aggregate information provided the information in the pool is large enough that you cannot derive the identity of the individuals from the reporting of the aggregate data. So you can ask for general hiring data, but you can't ask for specific hiring or promotion or discipline of an individual. Exceptions are the person in interest, the person, the record, the employee who is the subject of the record can look at their own personnel records. Their supervisor can have access to their records, and there are certain other exceptions to this exemption that can come into play, for example, for law enforcement purposes. Spence?
There's a question in the chat from Mr. Kurt Svensson. Attorney-client privilege can be overused, in my opinion. For example, is a legal briefing provided to the county's Charter Revision Commission regarding legal requirements associated with the redistricting process really exempt?
Well, I don't like to answer questions. One of the limitations on my office is I can't give legal advice to people per se. What I can tell you is the elements of the attorney-client privilege are that A, it is a communication between an attorney and a client. 2, about a subject matter that is within the scope of the representation of the client. So it can't be about somebody's what kind of birthday gift you're going to get for some mutual friend. It's got to be about your business representing the person, and it has to be confidential in nature. It's a privilege that can be blown by disclosure, in other words. So based on the bare facts that you just described, a lawyer is giving legal advice to a client on a subject that lawyer has been engaged to provide legal advice on. Yes, it is within the attorney-client privilege. Now, that doesn't mean that there couldn't be information within the communication that wouldn't be privileged. But as a general matter, just for example, my program is represented by an assistant attorney general. I frequently go to my assistant attorney general and ask for advice on some legal question or about the application of law to a particular situation. When my AAG gives me advice, that's privileged. That is subject to the attorney-client privilege. Would curious minds like to know? Maybe they would. I don't actually have that many interesting questions to ask, but yes. I mean, sure, you want to know the subject matter that public attorneys are engaged to advise their clients on are very often on matters that are of public interest. I mean, this is the tension I think you're feeling. It's a public body doing public business, and the lawyer's job is to advise that client, within the framework of the law as to how it can or should proceed, or to evaluate different options, or to assess different risks. That's what the lawyer's job is. So communications on those topics and along those lines, ordinarily speaking, would be privileged, even though they may touch upon many subjects of public interest. The law kind of puts a fence or a guardrail around attorney-client communications because the value judgment has been made that it is more beneficial on the whole to the public for a client and attorney to be able to speak very candidly to each other. So when a lawyer says, tell me everything, tell me all the facts, the good, the bad, the ugly, the client can do that knowing that it's going to be protected. And that privilege applies in public settings just as it applies in the private sphere. One caveat to this is it can be waived. One of the ways it can be waived, one way it can be waived is the client says, it's okay with me if you share it. I'm perfectly fine with letting everybody know what your advice to me was. That's one way it can be waived. Another way it can be waived is by sharing the information with people who are outside the privilege. So if the client were to call up the Washington Post and give them a scoop on this, this is what my lawyer just told me, well, as one of my old mentors used to say, the toothpaste is out of the tube. It's not going back in. So there are ways that the attorney-client, something that might otherwise be privileged can become disclosable. But ordinarily, if it's a communication between a lawyer and a client within the scope of the representation, it is privileged. Did I answer that? Okay. Specific information. So we're still on the topic of mandatory exemptions, but these are some of the exemptions that only apply to certain information within records and that are generally going to call for a redaction to the extent there is non-exempt content. So medical or psychological information, including as they may occur in 911 calls, police reports. I've seen this exemption invoked even as to photographs. Any form of record that may have medical information about an individual is going to be subject to this exemption. Sociological information is an interesting one. In order for an agency to be able to invoke this, they have to have adopted regulations that define what they mean by sociological information. But if they've done that, and if they've gone through that public process of adopting those regulations, then they can withhold sociological information that's in records. That often has been used in the past. We'll see how this plays out going forward, because there's as Joanne and I were talking before we got online, there's a bill in the legislature this session that will deal with things like personal email addresses and cell phones. But some agencies have used the sociological information exemption to exempt personal information they have in their possession about individuals, because there is no blanket exemption in the Act for such information. So they've gone about it indirectly using that section. Home address and telephone number of public employees, that is their personal telephone number, home telephone number, are exempt. Trade secrets and confidential commercial and financial information, that often comes up in the context of procurements. It can come up in other contexts as well. Personal financial information of an individual, that's a kind of a counterpoint to 4335, but it applies to individuals. Alarm and security system information, I think that should surprise no one. And 4352 is an interesting exemption. It generally applies to critical infrastructure, and I believe has its origin in the events coming out of 9/11, and has been, it was devised to protect critical infrastructure. Interestingly, this exemption was used to protect information about the storage of vaccines, the conditions of their storage, because during the height of the pandemic, this was considered critical infrastructure. The ability to deliver life-saving, health-promoting medicines, and the state wanted to protect that so that it would be safe and secure. Anyway, those are some of the mandatory exemptions that apply to specific information. Trade secrets and confidential commercial and financial information. This is actually kind of a complex exemption to apply, in part because the law is in a state of flux. It's probably best dealt with in a different setting, because it is kind of complicated. But in general, information that a business or company ordinarily would not make public, but which it is providing to the government as part of that agency's transaction of public business, is eligible for protection under Section 4335. This is an example of an instance where an agency very frequently is going to have to consult with a private party to find out how that private party views the information in order to assess whether they're going to assert this exemption or not. My office has had quite a few matters involving this exemption. Very frequently, businesses will use the PIA to prospect business with the state or local governments, and they want to know what their competitors are doing. And so that is a very frequent context. where this exemption comes into play. Are there questions we haven't covered yet? Or should we?
I think we've gotten to everything we can in the chat, but please feel free to share more questions, raise your hand, type in chat.
I would say that if you think of a question later that we don't get to today, you'll have our contact information. Feel free to reach out, and we'll try to address your question. I see Kurt has a question.
Can I speak, or am I being heard?
Yes, I hear you.
Okay, cool. Yeah, I'll keep it brief. I know I've hit a lot in the chats and so forth. A general question about contacting you all. Is that, do you guys have like a ticket system or something? I sent an email a while back and didn't get a response. It was a very detailed email and so forth. So I know you're probably really busy and all that, but so I'm just wondering, is there a protocol or a process that like, do you have a ticket system or something in terms of help requests and so forth?
No, we don't have a ticket system.
Okay.
I would like to hear from you, perhaps outside of this meeting room.
Yes.
What address you were using to contact us, so we can
Okay.
verify whether or not
Okay.
that was an approach. But generally, we try to respond to emails as quickly as possible,
Okay.
and in the order received, subject sometimes to the need to go out of order if there's some compelling circumstance. So
Understood. I just wanted to know if maybe there was a specific number to call or email to send to or whatever.
we do. We're going to give you a phone number and an email address and a slide at the end of this presentation.
Very good. Thank you.
You're welcome.
Yeah, in generally speaking, we do respond to everything normally within 1 to 3 business days. If it's a request for mediation assistance with a PIA dispute, intake normally occurs every 3 to 5 business days. If we don't receive an email, sometimes our email system may reject it as spam.
Yeah,
our emails get rejected as spam on a regular basis. So we do apologize if that does happen. The only instance where we may not respond to something directly is if our office is just copied on some of these emails that come in where it's out of our subject area and the email isn't directed to us to begin with. But still, even then, we review it and then we will follow up with an individual, usually just acknowledging at a bare minimum that we've received it, and that unless there's a request of the ombudsman, we're not going to be responding or discussing this any further. But please feel free to let us know if we can be of assistance. So I do apologize if something was missed, but we really do flag everything and get back normally within 48 hours.
Excuse me, can I ask a question?
Who's speaking?
Harvey Gallen. I
Harvey.
have no computer skills, and I was late getting on because I couldn't figure out how to do it. But anyway, I got on late. Is what you discussed in print, and can you get a copy of this PIA information?
Yes, we are going to provide through Joanne and Common Cause this entire slideshow, plus several other one-page handouts that we think might be useful to people. So everything that's being shown on the screen today will be made available to whoever attends or whoever asks for it.
Okay.
In addition, this whole training is being recorded and will be posted by Common Cause, and with Common Cause's permission, we will also link to it and post it on our website. So someone who came in late will be able to go back and hear the whole thing.
All right, thank you. But the question I had, the county executive is in the process of employing a new police chief. Is he forced, or can you request all the parties that were considered for that position?
Ordinarily, the specific application materials of candidates will be considered personnel records. Their job applications, resumes submitted in connection with the application, letters of reference they may have submitted. If they had to submit transcripts from their education or documentation of their education, all of that typically is going to be considered personnel material of those individuals that is not subject to disclosure. Is not subject to disclosure other than to the very narrow group of people who are allowed to see it, such as the person in interest, or that if that person is hired, their supervisor, or an interview, the hiring authority itself. Sometimes some statutes will make an exception, will override the personnel records exemption. So for example, when the Attorney General's office was looking to hire an ombudsman, the PIA ombudsman, the statute provided that the resumes of all the applicants would be posted online, would have to be published. So that's an example of a legislative override of the personnel records exemption. In fact, I even recall the Attorney General's office called me and said, would you like us to redact your personal phone number and your home address? So to answer your question, ordinarily, these types of materials are off limits.
Thank you.
By the way, let me just clarify something. When I say things are off limits, I'm talking about records. I'm talking about records. I'm not talking about a press conference, for example, where somebody gives a news conference and said, we have searched the entire country for the most qualified chief of police, and we are currently looking at, we've narrowed the list down to 10 people, and we'll get back to you later with further announcements. I mean, that is perfectly permissible. Things that government may say to assure the public that they are, casting an appropriate net in their hiring practices. That's okay. But as far as getting the actual applications and the records, that is what is off limits.
Kurt has his hand raised.
I don't want to bump anybody else out, but what about like if just like memberships of working groups that are established, like if a task force is set up involving citizens and council members, but it's done by a particular department in a county, is that somehow exempt from disclosure about who the members are? And
so the way I would approach this question is to, first of all, remember what we are talking about with the Public Information Act is access to records, So if you were to ask the agency or the department, all records relating to the creation of this task force, right? That would then cause the agency to go through its records, see what records it has. Once it has the responsive records compiled, it needs to go through those records to see if there is exempt content in there. And there might be. For example, there might be personal contact information of public employees that would be exempt. There might be, there could be other content that would be exempt. But in general, what they have to do is first, see what records they have. Number two, go through the records and see if there's anything to which an exemption would apply. If it's mandatory, they know they cannot release it. If it's discretionary, which is the topic we're about to get to, they have a few more steps in their analysis they have to go through. But that's the way I would approach it. There is nothing in the act itself that says thou shalt produce task force records or thou shalt not produce task force. There's no such provision in the act. You have to go record by record.
Right. And I guess I was trying to keep it simple to avoid extra work, because really all I wanted was a list of members of the task force. So just to,
yeah, I mean, you could ask for that.
Just ask for that.
Just ask for that.
Yeah. Okay. All right.
Generally speaking, I know of no exemption that would prohibit the release of the identity of task force members.
Of task force. Okay.
We have a couple more questions in the chat too. First, I'm going to read Alan Bowser's question. And Lisa, I'll take the lead on this one and you can piggyback, certainly. What are the prerequisites for mediation and how often do custodians fail to timely respond? So generally speaking, the prereq to requesting mediation with the Ombudsman is that you have to file a written Public Information Act request with the agency, and then receive a response, and that response may have a dispute in it, such as your denied records, or your provided records with redactions, and you challenge the basis for the redactions. You receive a fee estimate letter, and you believe that the fees are excessive. You request a fee waiver based on public interest or indigency, and they never respond to your fee waiver request, or they deny your fee waiver request. Or it may just be as simple as the agency responds and you don't believe them. Any number of issues can be attempted in mediation, but generally request and response are what we ask for. Now, certainly there are times, like you noted in your second question, how often do custodians fail to timely respond? There are times that you're submitting for mediation, I receive no response to my written request. So normally the PIA does afford an agency 30 calendar days to provide a final written response to you and produce records if they're able to. If 30 days can't be accomplished, the Act does request that the requester and the agency work together to establish an exemption up to 30 days. So 60 days total from, and correct me if I'm wrong, Lisa, 60 days from the date that the PIA request is submitted to the agency. In recent years, custodians' failure to respond, what we have casually internally tagged as MIA issues, they ballooned, especially with the pandemic. And even in recent years, as agencies have been recovering from work from home and pandemic-related stressors that cause delays in responses, an agency's failure to respond was a bigger issue than it really should have been if you review the metrics of our office since the office opened in 2016. Now, in the past year and a half, we've seen those numbers improve back toward about the 20% mark of disputes that are presented for mediation. And we work actually very proactively with a number of agencies outside of the context of mediation to try to get responses out the door to correct issues when we see them, patterns of non-responsiveness. So that way, if there is a matter that's coming to mediation with Lisa, it's not the agency didn't respond, it is something more tangible like a denial or a redaction issue or a fee issue. We're seeing great success there. So with the materials that we are going to provide Joanne after this training, I'll make sure to include a link to our statistical reports that are included every year in the PIA Compliance Board's annual report. The board does give Lisa a section of their report to discuss what's gone on through mediation, and we do publish every year a yearly and a since inception fiscal report, so you can kind of see trends of issues in where they've gone throughout the years, and you'll see that the 2020 to 2022 timeframe, an agency's failure to respond has spiked up, but that number is coming down, and we expect the number to look much better in the coming report that will be issued September of this year. Lisa, did you want to add anything onto that?
I think you covered it very comprehensively. I would just say that we do publish statistical data about our program's work, and including the types of issues we're working on, the frequency with which they're seeing them, the types of agencies we're working with. We publish that every year. At the end of 2019, we published a report that the legislature asked for. It's also available on our website. We'll give you that address, but it included a survey of 23 cabinet level agencies on a variety of topics relating to PIA compliance. And there's data in that report that was that was as of the reporting time, which was sometime in 2019. So that will give you an idea, I think, of at least what agencies will tell you about themselves, their own self-reporting, and then our reports will tell you what we're seeing on an aggregate basis in mediations.
Absolutely. It's our pleasure, Mr. Bowser. Sophia Jones had a question about fees. Could you outline the payment process for PI requests in Maryland? I recall that if it takes more than 2 hours to recover records, there may be payment requested.
Let me defer, if I can, that question to the fee section, because we are going to cover that. But yes, you're right. You get 2 free hours. The agency can recover actual costs above and beyond 2 free hours. And so we'll talk about that when we get to the fees.
And then Jennifer Adams asks, if a committee within a government agency is not under the Open Meetings Act, can the names of those members be disclosed?
The Open Meetings Act does not govern what is disclosable under the PIA at all, for the most part. So again, I know of no exemption under the Public Information Act that would bar disclosure of the names of the members of, some government committee, provided the agency that you're asking for has a record that contains that information. And that agency is subject to the Public Information Act, and there is no exemption that would prevent them from releasing it. So I know of no exemption, but that would be the analysis. The Open Meetings Act is really is a separate statute, and it operates independently of the Public Information Act.
And I think that brings us current on our questions. So if there's nothing further, Lisa, we can take.
I notice we are going to be right up on the 2:30 end mark, which is the sign of, we're okay? We're okay? Good. Okay. But I will try to move it along, and I really appreciate the questions because the training is for you. So we're going now to Part 4 exemptions. Part 4 exemptions are purely discretionary, meaning the law does not tell an agency that yes, they should withhold it, or no, they can't withhold it. It basically says it's up to you, custodian, to weigh the balance of interest and determine whether or not to disclose a particular record. So we'll go over a couple of the most common, in my work has proven to be the most common discretionary exemptions. Section 4344, which governs inter or intra-agency letters and memoranda that is, in the words of the statute, that would not be available to a party in litigation with the governmental unit. We'll try to unpack that a little bit. Investigations and security procedures, section 4351, has been very much in the news over the last several years. It relates to certain types of records in the possession of law enforcement agencies, generally speaking. Section 343 is kind of a threshold question that applies to all discretionary exemptions. And that is that the custodian must make the initial judgment whether disclosure of the record would be contrary to the public interest. There can be materials that would be, in theory, subject to some of these exemptions, but there's absolutely no reason not to withhold it. There's no reason to withhold it. So section 343 is a preliminary type of consideration whether or not the public interest would warrant withholding something that the law permits the agency to withhold.
If I might chime in real quick, y'all heard it here first. We're about to announce a special training that focuses in on these discretionary exemptions. So mark your calendars, April 20th from 12:30 to 2 p.m. It's the second part of what we're billing as our brown bag lunch training series, where we try to focus in on very specific topics under the PIA. The announcement should be going out by the end of the week, well, by the end of the day tomorrow. There will be a registration process to receive the Teams link. Anyone and everyone is welcome to join. So if discretionary exemptions and deliberative process are your curiosity of the day, please join us. We would love to have you.
Yeah, that's great. And the reason for doing that is because these exemptions are some of the hardest to apply, just because they do involve a judgment call. They involve a judgment call, and there's always some tension between the underlying purpose of the act and the purpose of the exemption that allows certain records or information to be withheld on a discretionary basis. So without further ado, let's move to, I think, yes, our personal favorite, the interagency or intra-agency letters or memoranda. Generally speaking, I mean, this is one of the most common exemptions that have ended up in my caseload. And I think that is the case, both because they are discretionary, and secondly, because materials that are withheld under this exemption very frequently go right to the heart of what the purpose of the PIA is, which is to allow citizens to know what their government is up to, what they are doing, why they are doing it, how they are doing it, what they considered, and what else they considered. And so that is the fundamental purpose of the Public Information Act. On the other hand, the Public Information Act also says that certain inter or intra-agency documentation that could be withheld from the party if they were in litigation can be withheld on a discretionary basis. Most often, what this is alluding to is something known as the deliberative process privilege. And that privilege typically gets it is intended to apply, when it does, to discussions or vetting of decisions that have to be made. So the discussion has to be both pre-decisional and it has to be deliberative in order to be eligible for withholding as subject to the deliberative process privilege. This is a privilege that can be invoked by both, top executive level officials as well as lower level administrators and workers. It can cover big decision making with lots of ramifications, all the way down to a decision whether to grant a change order in a contract. So it can govern the big picture general right down to the particular. And it is purely discretionary. It also has been held to cover something known as attorney work product. So attorney work product, to simplify it, generally means it's material produced by an attorney, quite often in a situation, a context in which there is an anticipation of litigation or a potential litigation. And so it could be a legal analysis of the client's position. It could be weighing the pros and cons from a legal perspective of different pathways. But it is something that in a government context it often appears in the form of an inter or intra-agency communication of some sort. And so those are in a big picture way, in a very generalized way, that is what Section 344 is about. A couple of points to keep in mind. I don't know if we have this on the next slide, Spence. Do we have another slide on this particular? Not yet. No, we don't. So let me do a couple more words about 344. It generally does not apply to factual material. So if there's a factual background discussion or things that are just kind of going over historical matters, the background of how we got to where we are today, generally those are not going to be deliberative. And that content is not deliberative per se. It also typically will not cover, it's not intended to cover things that aren't confidential. So people can deliberate. I mean, most government workers are deliberating about something every day, but this exemption is obviously not one that is intended to swallow up the general rule of disclosure. And that's really where the tension is, I think, and where one has to be it has to be applied very carefully and with really full consideration of the purpose of the Public Information Act to begin with. Otherwise, it can be, in my opinion, it can become an exemption that swallows up the general rule. Okay. Investigative records are another type of discretionary exemption. By the way, whenever you have a discretionary exemption, any discretionary exemption, the custodian should be explaining, if they haven't provided you a redacted document, they need to be explaining why they cannot provide you with a redacted document. So the discretionary exemptions contemplate that some portion of a document may well be disclosable. And if they're not, the agency must say why. So the investigative records are records that pertain to investigations that are in the possession of certain named agencies, including the Attorney General's office, state's attorney's offices, a municipal or county attorney's office, a police department, a sheriff, and potentially others. This is not an exhaustive list, but these are the enumerated or listed named agencies to which this exemption applies. Some others that it might apply, the state prosecutor's office isn't mentioned here, but it has been held to be a law enforcement office entitled to invoke this exemption. Inspector generals may in some circumstances qualify, and there can be other types of offices that may on occasion be invoking this exemption. The purpose is to protect investigatory files that are compiled for law enforcement, judicial, correctional, or prosecution purposes, or that contain intelligence information or security procedures of these agencies. Records of alleged police misconduct, what is often referred to as the internal affairs files of police departments, may be protected in whole or in part as investigative records under this exemption under Anton's law. And prior to Anton's law, they were automatically off limits as personnel records. Now they may only be withheld on a discretionary basis if they qualify under the investigative records. Very frequently, it will be relevant in terms of determining whether or not it's in the public interest to disclose or not to disclose, to know whether or not there is an actual ongoing open investigation or prosecution, or if the file is closed and the investigation is concluded. It's also important to bear in mind that just because an agency is a law enforcement agency doesn't mean that every record that it holds is going to be exempt as an investigative record. So this is really intended to protect the specific investigatory or security related documents of law enforcement agencies. Subsection B of the investigative records exemption applies to when a person in interest makes the request. Person in interest being the person the record is about. And when a person in interest requests the records, an agency they can only withhold it. It's only eligible for withholding if one of these 7 listed circumstances apply. And most of them, I think, are pretty self-explanatory. The purpose of the exemption in general is to protect the integrity of investigations, the ability to bring effective prosecutions, to prevent undue publicity or tainting of jury pools and the like, as well as to protect individual personal privacy of persons who may be involved in investigation, witnesses and the like. So the thing to remember is if you are a person in interest, you have a broader right of access than if you are simply a reporter from the Washington Post who wants to know something. If you're a person in interest, your request can only be denied in whole or in part under this exemption if one of these circumstances apply. If you're a reporter from the Washington Post, the agency has to balance the public interest in disclosure versus the public interest in protecting the confidentiality of investigative information. So this particular exemption has been very much highlighted by all of the scrutiny of law enforcement officials and our criminal justice system more broadly. So it's an evolving area of law. I think that's fair to say. Okay, temporary denials. This is brings up the topic of the special court order. This is not really an exemption so much as it is a mechanism by which agencies can go to court and get a ruling from a court that something that they would be required to disclose, they will be allowed to withhold. And generally it requires a showing of something pretty substantial, some very serious and substantial concern about a harm that would come about by release of the record. It's rarely used, but in those instances I'm aware of where it's been used, it's the concerns have been quite substantial, usually having to do with public safety. In order to go through this process, an agency will have to temporarily deny the request, issue a response letter to the requester that says, I'm temporarily denying your request under this section. And then the agency must file a petition with the court within 10 working days of issuing that letter. And then the court will hear the matter. The person who has made the request is entitled to participate in this type of proceeding, is entitled to participate, but is not required to. Again, I say this is a very rarely used mechanism or process, but it is an important one to agencies because the Act cannot cover every conceivable circumstance that might ever come up for all time. And so this gives agencies who have some very serious concern, but they have no exemption they can put it in, to go to court and ask the judge to give them permission to withhold it. So one of the examples I'm aware of is a number of years ago, the health department was asked for a list of abortion providers, abortion services providers. They had very serious concerns about providing that list because at the time there was a lot of violence occurring all over the country against these types of facilities. They went to court and they got an order that they were not required to disclose the list. There are a couple of other instances that of which I'm aware. The ones I'm aware of all involved issues really of public safety that could not be captured by some other exemption. Okay, so where does this leave us? Common question, is there some kind of general catch-all exemption? And the answer is no, there really isn't. The closest thing we have to a catch-all exemption is what I just described, the mechanism of going to court to get an order that allows you to withhold something that the PIA would otherwise call for you to disclose. How about it's against the public interest to disclose this? Nope, not unless there's an exemption. You have to find an exemption that applies. It would be an unwarranted invasion of privacy for us to disclose this. Nope, not unless you have an exemption, and not unless the legislature has carved that out and said, no, that is off limits. Unwarranted invasion of privacy is not a standalone exemption, nor is, I think it's contrary to the public interest, not an exemption. And this is kind of a summation of the exemption landscape. It's kind of a quickie for agency custodians. If it's a mandatory exemption, then they should withhold it. If it's a discretionary exemption, they should only withhold it if the public interest in withholding outweighs the public interest in disclosure. So they're necessarily balancing competing interests in that scenario. If there's no exemption, you can only withhold it if the court gives you permission to withhold it. And then you have to follow those very specific procedures for issuing a temporary denial. If only part of a record is exempt, then you redact, produce the rest. And do we have more questions?
There are no more questions in the chat. We have about 19 more minutes left of this session. So
let's plow ahead.
If nobody has anything, we'll push ahead to the end section. And again, you can always follow up with us afterwards.
Let's do it. Okay. Now we're going to talk about things having to do with agency response times and fees and fee waivers. Okay, time limits. Everybody knows that the Act provides time limits and that agencies are supposed to be producing things as promptly as possible. What does that actually mean? Well, as I think Spencer mentioned earlier, generally speaking, records should be produced within 30 calendar days of having received the request. There are some exceptions. For example, an agency can seek an extension with the requester of another 30 days. Or when things come into mediation, the parties can agree to allow extensions. If an agency gets a request and they can see right off the bat, it's going to take us more than 10 business days to fulfill this request, the agency should be issuing what is commonly referred to as the 10-day letter. And the 10-day letter is supposed to function basically as an acknowledgement of the request, an indication to the requester of how much time the agency expects it will need to fulfill it, the reasons it needs that additional time, and if they are anticipating that fees may be charged, they should be giving an estimate of the fees that they anticipate and some indication of why they think there will be fees. There are sample response letters in the PIA manual which you can refer to. If you're the recipient of one and you don't think it looks kosher, you can go to the manual and compare it to the model letters that the Office of the Attorney General has propounded. Finding the right custodian. This is something, this is often a source of delay and of things bogging down in the system when, for whatever reason, the request is not directed to the right custodian. If the request comes into an agency and they know they don't have the record, they should be, under the Act, under 4202, they should be notifying the requester within 10 business days that they are not the holder of the record, and they should be referring the requester to the proper custodian. I will let you know, my office gets we've received many requests for public records to my office. Some people apparently think we are the repository of all state records, and we are not. But we treat those as PIA requests, and we respond immediately by saying we are not the custodian of that record. You may want to submit your request to these agencies. So, but generally, what they're not allowed to do is ignore it. Okay, the denial letters. The Act provides direction to agencies about what information they have to provide when they deny a request for records. They have to give reasons. They have to give legal authority, meaning they should be citing one of the exemptions we just went through, which sometimes can involve other law, as we discussed, but they should be providing some legal authority for the denial. And a notice of remedies. We're going to, as you see at the bottom of the screen, the current remedies available under the law involve mediation through my office. When mediation doesn't resolve a dispute, certain types of disputes are eligible to go to the board for review and decision. And the courts are always open and available to receive lawsuits. My process and the board process does not preclude anyone from going to court at any time, whether it be an agency or a requester. And I think I did mention this, when a discretionary exemption is, when it is invoked, the agency should be explaining why it balanced the public interest the way it did, why it found the balance of interest weighed in favor of withholding some material, and why, if they're not producing a redacted record, why they couldn't produce it in a redacted form. So if a denial letter contains all these components, then I would say it may or may not be legally correct, but at least it is conforming on its face to the requirements of the Act. When a denial letter does not have this information, it is what I would call a non-conforming response. So we see a lot of matters involving those types of issues. Okay, fees. We've mentioned that agencies can charge fees in certain circumstances to recover their actual costs. There are limits. However, first of all, the fee has to be reasonable. And by reasonable, what this means in this context is the fee must have a direct connection to the recovery of the agency's actual costs incurred in fulfilling the request. And that can include search and review time. That can include labor charges of the employees who are tasked with performing work necessary to fill the request. Every requester gets 2 free hours per request. And then sometimes agencies have other types of actual out-of-pocket expenses, you know, in less frequently today, but sometimes agencies will incur costs for photocopies, sometimes for thumb drives or discs, things of that sort. They can be, those costs, those direct actual costs can be passed on to the requester. Anyone who wants to delve into this a little more deeply, the PIA Compliance Board, up until July 1 of last year, could only hear disputes about fees that were over $350. All of their decisions are published. And so if you go on to the Office of the Attorney General website and you follow the links for the Public Information Act under Open Government, and then go to the Public Information Act Compliance Board page, you will have links to all of their opinions. And everything prior to July 1 of last year will be dealing with fee issues, fee disputes. Now the board has an expanded jurisdiction and they can consider a number of other topics, including denials, which we'll get to. But you can glean a lot of information about how this provision is being applied and viewed, at least by the compliance board when disputes have arisen. When I'm doing trainings for agencies, I frequently will remind them to be, to consider how fees may be perceived and how they may function as an actual barrier. So sometimes, in other words, to use professional judgment. This is not simply a matter of doing an arithmetic calculation all the time. If a requester, I did have a matter once where a requester received an estimate of $1 million for public records, and understandably that person hit the roof. So there was an actual calculation that was done that resulted in that estimate. But when you see something like that, you wonder who on this earth is going to paying or even consider paying $1 million for access to public records. So some other solution in that type of situation needs to be devised. Which brings me to some of the work we do. In case of a disagreement, you can consider requesting assistance from my office, and this can be done either at the instance of the requester or the agency. Fee waivers. Agencies are entitled in some circumstances to charge fees, and requesters are entitled to ask that they be waived. If you're going to ask for a fee waiver, make that request in writing. If possible, when you submit your PIA request, there are 2 general bases for asking for a fee waiver. One is because waiver would be in the public interest, given, and then you have to fill in the blank. You have to say why it is in the public interest, because of the nature of the request, because it is a subject of intense public interest, because the requester is intending to use the information and broadly disseminate it to the public. That would apply to members of the press, for example, or the requester is going to use this in terms of developing commentary on regulations or proposed law. So purposes that directly tie the request to the purpose of the PIA itself, this is just Lisa Kershner's opinion, are factors that should be considered as weighing in favor of the public interest. They're not, it's not an exclusive list, but it's one of the approaches I frequently will take into consideration. Financial ability to pay can be a factor. And I usually suggest to requesters, when you are requesting a waiver, try to be as specific as you, particularly when relying on public interest, to be as specific as you can be. as opposed to saying, for example, it's in the public interest because this is an important topic, right? Yes, it's an important topic, but the real question the agency is looking at, why is it in the interest for the public fisc to absorb this cost as opposed to you individually or your organization to absorb it? Indigence, which is a kind of a legal term of art, is another basis on which a waiver can be requested. Only an individual can assert this. This does not apply to organizations. There is a legal definition of indigency. It is tied to the median household incomes as it is adjusted periodically and published in the Federal Register from time to time. It's a very cumbersome type of definition. I would suggest that anybody, if you're working with somebody who needs this type of waiver, to consult the PIA manual, which contains a sample affidavit of indigency. If requesting a waiver on this basis, an agency can expect an affidavit to be submitted attesting to the person's financial situation and documenting that they meet the criteria for indigence.
Before moving on real quick, I'll note, Lisa mentioned that July 1 of last year, the board had expanded jurisdiction to deal with a number of issues beyond excessive fees totaling more than $350. Fee waiver denials, the board cannot consider them. That is one of the issues that Lisa frequently deals with in mediation. It's most often tied to excessive fee disputes as well. But if a fee waiver is denied and it's not resolved through mediation, the board will say, if you attempt to file a complaint, that they regret that they don't have the jurisdiction. Just want to put that out there.
Yeah, the board will cover this in a little more detail, but the board does not have unlimited jurisdiction. It still has a delineated jurisdiction over certain types of disputes. When I'm doing trainings for agencies, I try to urge them to take these kinds of common sense steps. Number one, they get a very broad request in, communicate with the requester, find out what they want. You may have to have a conversation about what kind of records you hold, how they're maintained, what it's going to take to access them. Providing that information will help the requester understand why a fee is likely to be assessed or why it will be expensive. Agency custodians know better than most requesters how the records are kept. So the agency personnel are in the best position to help a requester be specific and find what they're actually looking for. Of course, this all requires good communication. So, in an ideal world, people would be communicating freely and often and productively. That doesn't always happen, and particularly always doesn't happen on a timely basis. And so my office, when we get fee issues, we're frequently working on some of these kind of these communication basics, as I put it. Suggest alternative approaches for getting the information or the record. That frequently can help a requester narrow a request, pare it down, take it in stages. Importantly, there's no limit on the number of record requests someone can make under the PIA. For those of you lawyers out, if there are lawyers attending, this is not like a request for production of documents in litigation where you're limited to 30 or whatever the number is. It's been a while since I've had to do that, but whatever the number is, that there is no limit to the number of record requests that can be made. So you don't have to get it all in one bite. You can think about staging, focusing, and working your way from the central to outward, and strategies such as that. If you're not making progress in your discussions or you feel stymied, please feel free to get in touch with my office and ask for help. This is what we do. Which brings us to remedies and enforcement. I think we got two questions in advance of this training that were submitted that had to do with remedies and enforcement. Currently, under the current law, there are three major paths to remedy either violations or deficiencies, so if someone feels they've been treated wrongly under the Act, to get relief. One of them is to pursue voluntary mediation through my office. And that's done very simply by submitting a request to us for that type of help. You can do it through our website, you can do it through our direct mailbox. We'll provide you with that information, and we will respond with information about our process and timeframes and the like. The Public Information Compliance Board is a separate independent body that has the power to review and actually decide complaints. And it issues published decisions on matters that are submitted to it and that are within its jurisdiction. As of July 1, as of last year, July 1, that board now has the authority to review any denial of access to a record, a denial, whether it's partial or entire, withholding of an entire record, denial of an entire request, redactions that are made. It has the authority to review all of those decisions. It still has the jurisdiction it had from the very beginning to review fees that are more than $350. It has the power to address problems where an agency fails to respond at all. And it can order certain relief in regard to those failures. It also now, for the first time, has authority to review complaints by custodians that an applicant's request is frivolous, vexatious, or in bad faith. So I don't believe the board has yet received anything of that nature. I think by the language, you can tell that this is intended to address a rather extreme situation. But the board does now have that for the first time, have that authority and can issue relief if it finds that a request is frivolous, vexation, or in bad faith. The caveat: in order to file a complaint with the board, a person must have first attempted mediation through my office. So you cannot get to the board without first making a stop at my office and attempting to mediate. And that's true whether the agency initiates it or the requester initiates it. Judicial review is the form of remedy and enforcement that has always been in place. Courts are empowered to review complaints about violations of the Act and to issue appropriate orders. And in certain circumstances, you can, if successful, you can recover costs, and in some circumstances, you might be able to recover fees, attorney's fees. Those are the three main pathways for enforcement. Okay, changes to ADR. I think we've just covered this really. Must come to me before you go to the board. It's only if we're unable to reach a resolution and the issue is within the board's jurisdiction that you can then go on to the board. The board's expanded jurisdiction includes denials, fees more than $350, failure to respond, and the problematic frivolous or vexatious request. Board still cannot review denials of fee waivers. Okay. Some of the features of my program is, one, it's entirely voluntary for both parties. It is also entirely confidential. My office is prohibited from releasing any information we acquire in the course of handling a mediation or even discussing the possibility of mediation with someone. I use most of the traditional mediation techniques, meeting individually with parties. Sometimes we convene a group meeting as appropriate. Sometimes we will ask to review records if we think that may be of assistance. And my office is able to consider any dispute whatsoever. There's no subject matter limitation on what we can take up in mediation, other than it has to relate to the Public Information Act. Anyone can request mediation. A requester or an agency can ask for mediation.
Only thing that I would add in here, some folks may wonder, well, if I request mediation from the ombudsman and the agency declines to mediate this issue, it's voluntary. Does that shut me off from the board? It doesn't shut you off from the board. When we open the mediation file, we do notify the agency that if they decline mediation, we would issue a final determination stating that the matter remains unresolved. And that does satisfy one of the conditions to potentially file a complaint with the board, because mediation was attempted. So your due process rights in ADR and in the judiciary both are fully preserved, even if one party does not opt into mediation.
That's right. You can't force anyone to mediate, but if the other party declines to mediate, all you have to show is that you attempted it. You attempted it. Okay, and this is a recap kind of the changes. You're also going to be getting another handout with this slideshow that outlines these changes. Mediation has to be attempted with my office before you can proceed to the board. My office now has up to 90 days, 90 calendar days to bring mediation matters to closure. Previously, I didn't have any deadline, so this has kind of forced us to tweak our process a little bit. In general, I think having this deadline has helped keep things moving because we are able to, we have an objective basis to tell people we're on a schedule here. This can't go on indefinitely. If the dispute is not resolved in the mediation, and we will issue something called a final determination that says the matter is unresolved, the complaint would have to be filed with the board within 30 days of receiving that final determination. Just a point of clarification, there's no time limit for bringing something to mediation to begin with, meaning you can do it within 30 days, within 60 days, 90 days, a year, whatever. We've even had matters come to us years after request. I don't recommend it, but there's no time requirement for getting things to my office. But once they get to my office, the clock starts running. 90 days to resolve or make a determination that we can't resolve the matter. 30 days from receipt of the final determination to go to the board. And then the board has jurisdiction, as we've just mentioned, over these several new areas of dispute. And for people who would like to learn more about the board's process, the board adopted regulations last year that outline its process. The actual complaint and response procedure. It describes some of the powers the board has and tools it can use, including convening conferences, directing parties to produce records to the board for review, and other tools at its disposal. You can go to the board's website and read about that in more depth. Okay, and of course, parties can still go to court. No one is required to come to the ombudsman or to go to the board at all. You can go straight to court if you wish, and some matters warrant that. If you go to court, you're generally going to want to have a lawyer advising you and representing you. So I don't spend too much time on this area, just to be aware generally that courts have the power to issue orders that can either command someone to do something or to stop doing something. It can, in certain circumstances, it can assess damages, and it can assess fees and costs. So the court has a range of powers that are not they're certainly not available to me, and that some that are not even available to the board. And here you have, there was a question earlier about how to get in touch. We respond to all of these forms. Email at our PIA.ombuds dedicated mailbox. We monitor that multiple times a day. Our general office phone number is given. Please feel free to consult our website and follow us on Twitter. We try to make announcements about information about events like this, trainings, changes in the law, things that may be of interest to people who are using the PIA.
And if for some reason you don't hear from us, again, just to kind of get back to what was said earlier, we make every effort to respond to absolutely everything. And if you don't hear from us within 3 to 5 business days, it's very likely that our technology overlords have betrayed us in the transmission of this information. So give us a call at our general number. Leave a voicemail if we don't pick up. The voicemail is emailed to us. but we are here as a resource and happy to help. And in many respects, contact from requesters and records custodians both have helped to preempt the need for mediation down the road. We've been able to proactively resolve issues, answer questions, get a level of understanding, and in the end, it's a win-win for everyone.
I don't know if there are questions.
Yeah, I wanted to, before we break off, I wanted to give a opportunity in case there were final burning questions. Feel free to include it in the chat or raise your hand. If not,
Kurt did have one question, but I did encourage him to follow up with us offline. I think it does merit a bigger discussion.
so with that said, I want to thank both Lisa and Spencer for spending the afternoon with us and for kind of going through a very detailed training. Like even myself, as we were reviewing, I was refreshing, getting a refresher on the PIA and how we can truly be helpful to members as they are reaching out with questions and so forth. We are hoping to continue hosting events like these yearly. So ideally, our goal is one PIA training a year. We're hoping to host a Open Meetings Act training later this spring. And once Lisa and Spencer provide the information for the brown bag event on, I believe it's April 20th, we will make sure we share that information with our list as well, directing you all with their information on how to register. Again, we do have a short form that our fellow Isabel is going to drop in the chat. Obviously, we work on everything from the Public Information Act to open meetings. We have also been working at the local and state level to expand access to government proceedings. If you are engaged in Annapolis during session, you'll see that you can testify and so forth remotely. Those are things that our organization and our partners are working to maintain, and we're hoping to have that trickle down at the local level. So the form that Isabel is dropping has questions that if it's not relevant to you, feel free to skip them and go straight to PIA. And obviously feel free to email us if you have any questions. Following today's event, it'll either be later this evening or tomorrow morning. It depends on how quickly the recordings become available and how quickly we can load it all onto YouTube. But we will be sending an email to you all. It will have a copy of the training slides. It will have a recording, any additional information that Lisa and Spencer want to share. I know that there was someone who wanted to share contact information. We won't be sharing contact information of people who registered, but what we'll do is put an optional Google form in there where you can choose to opt in, with the understanding that individuals who registered for the training who aren't here today, that they'd have access to that information too. But again, thank you all so much for coming out, for participating in our Sunshine Week event. And again, special thank you to Lisa and Spencer, who again responded to our emails fairly quickly, so they are very responsive, and who is willing to make themselves available to join us today. So thank you all so much and have a good afternoon.
Thank you.